Welcome to Theme 2, Rights and Responsibilities of the AQA GCSE Citizenship course. We're looking at rights and responsibilities within the legal system, and in particular, how does the court system work in the UK? We have quite a bit to cover in session 6, but in this video we are going to be looking at the top 2 bullet points. Firstly, what is the difference between statute law and common law? Secondly, why is it important to have both statute and common law? So what is the difference between common law and statute law? You should probably take notes in a table titled Common Law on one side and Statute Law on the other. Statute law is also called legislation. These are laws passed by Parliament, e.g. the Equality Act 2010 or the Police and Criminal Evidence Act 1984. Ultimately, statute law refers to the legislation that is debated and discussed in Parliament and is agreed to become an Act of Parliament. Common law is different. These are laws based on judges' rulings that evolve or develop over time, based on previous court cases. These are called precedents. Precedents refer to these previous cases that have changed or created a principle or rule. For example, if a judge is confronted with a murder case, we know that murder cases can be very different from person to person, and therefore the situations and circumstances are completely different. This also means that the judge needs to provide a fair sentence that achieves justice. What the judge will do is base their opinion of the sentence on previous cases that are similar to the case that they're deciding the sentence for. These previous cases are called precedents. The term common emphasises that these rulings must be applied across all courts in the UK. There's clearly some differences here between statute law and common law. Common law involves judges' rulings. Statute law involves the discussion and debate that takes place in Parliament for legislation to be passed. Statute law also start off as bills. This ties into your politics and participation unit, as this will be covered in the video about how laws are made. So they start off as bills before being debated, discussed and voted on by Parliament. Once they get royal assent, so this is when the monarch signs it off, they finally become an Act of Parliament. That's why these types of laws end with the term Act. In terms of common law, this originated from the King's Court and the King's judges, as they travelled around the country, adopting what they consider to be the best legal rules and principles. Statute law is written and codified into law, and therefore are not as flexible unless they're being reviewed in Parliament after decisions made by judges, public appeals or pressure. For example, the Road Traffic Act might provide speed limits and punishments relating to speeding. This would have been discussed and debated in Parliament. It may lead to further debates and discussions in Parliament based on external pressures from the public as well as judges. Common law, on the other hand, is based on judicial decisions. The term judicial refers to judges and courts. Judges deliver written judgments on the case they sit on. The decisions may evolve and develop to deal with the ever-changing decisions in society. This means that they are flexible. And again, you can see judges deal with common law, Parliament deals with statute law. What we also need to consider at this point is that one of the fundamental aspects of the British Constitution is the concept of parliamentary sovereignty. What that means is that Parliament has the final say, and they have ultimate power. This is because they're elected in by citizens. This ties into statute and common law because decisions made by judges in court may influence the discussions and debates that take place in Parliament. We've compared both statute and common law and looked at the difference between the two. We're now going to look at why it is important to have both statute and common law. Why is it important to have both common law and statute law? Here's a picture of a judge, and here's a picture of the Court of Appeal. On one hand, we have statute law. On the other hand, we have common law. So when a judge considers a case that is brought to court, they would consider the exact wording of the law, as identified in the statute law, also known as legislation. However, if matters are unclear or ill-defined, meaning not well-defined, the judge's decision in their written judgment becomes common law. If the judgment is challenged in the Court of Appeal and set aside, then the Court of Appeal's new ruling becomes the common law on this issue. What this basically means is if a judge in a lower court made a written judgment and the person then appealed the judgment and went to the Court of Appeal, if the Court of Appeal decides that the judgment made by the previous judge was not correct, or they decide to set it aside, then the Court of Appeal's new ruling becomes the common law on this issue. Common law on that issue is no longer based on the judgment made by the previous judge, because the Court of Appeal has overruled that, and it's the Court of Appeal's ruling that then forms the new common law on the issue. Now, due to the judgments and rulings made by these judges that has impacted on the common law on that issue, it may then influence Parliament. So Parliament may decide to look at the matter again and pass redrafted legislation which clarifies the issue and therefore nullifies the common law. So they might adapt or change the original statute law to ensure that it's not ill-defined and much clearer taking into consideration the judgments made by the judges. This is the relationship between the judiciary and the legislator. What we mean by the legislator is Parliament, and what we mean by the judiciary is judges and courts. The relationship is that there is a separation of power there, but they both work together to ensure laws are fair and just, and to also ensure that power is not just centralised in one area. It is important to have common law and statute law. When preparing cases, a solicitor or barrister may need to research a point of law about the case. They will check any relevant statutes. So these are individual pieces of legislation under statute law. And then look at recent case law, i.e. precedents. This refers to common law judgments made by judges in courts. The recent case law decisions of the higher courts will be looked at to see if there is any guidance to assist those solicitors and barristers. The role of the solicitor and the barrister is to represent their client, and so they use both statute and common law to ensure that they can do so effectively. So while statute law provides legal framework for society, common law enables statute law to be applied in differing situations and allows statute law to be updated as required. This makes the legal system fairer. It also allows the judiciary to hold Parliament to account for ensuring legislation passed is correctly applied to cases, and in turn, it helps to provide the right to a fair trial, a fundamental human right. We've come to the end of this video where we've looked at the difference between statute and common law and the importance of both to ensure fairness and justice in the legal system. In the next video, you'll be looking at what we mean by the terms judiciary and the separation of powers. You'll also be exploring the roles and qualities of a judge. And finally, you'll be looking at how you become a judge, comparing the process in the USA to the process in the UK, with an opportunity to practice a 4-mark question.